count me skeptical about the origins of things like this. It was noted in the Alliance Defending Freedom press release on this issue. I think you touched it, but that there were like active and known pro-abortion advocates applying to jobs at Michigan Right to Life and at this reproductive health resource center, pregnancy resource center rather. This doesn't really happen organically, as far as I know. Like I said this last week when we were talking about non-discrimination in Illinois, like I would never apply for a job at the, Alliance for the Separation of Church and State or the ACLU because it's just obvious that we're not mission aligned. So I'm just skeptical that these are organic applications of people who really want to work there and feel discriminated against rather than I'm only speculating, but these seem like test cases that somebody found these organizations and these laws and applied to bring about litigation like this. I just don't see this happening in the wild. Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Alexa Kawlewski, a recent graduate of Notre Dame Law School.
Thank you for joining us for another episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we always appreciate it if you support this channel and podcast by liking the podcast, subscribing to the channel on YouTube or Spotify or wherever you're listening from. So this week we'll be covering first an appeal of a Colorado law that censors and essentially compels speech regarding so-called transgender identity. And we'll go to a lawsuit in Michigan concerning yet another attempt to smuggle abortion into the protection against sex-based discrimination. This will have echoes of a case we covered last week. And then we'll end with a new lawsuit in Washington State concerning a kind of very troubling alleged sexual assault as a result of a boy playing girls' sports. So let's start in Colorado, where we tend to start bad religious liberty lawsuits fairly frequently. So this one, we've covered this in the past. One of the cases, there are two cases here. They're both Colorado companies. One is called XXXY Athletics, as in XXXY chromosomes. And the other company is called Born Again Used Books. These are both Christian companies that are challenging a law that would require the companies to use the preferred quote unquote gender expression in their interactions with customers and in their advertisements. So you probably already get the gist. The recent Colorado law amends the Colorado Anti-Discrimination Act, which is often called CADA. And again, that's an acronym that we use quite often here, it seems, from poor Jack Phillips to Childs v. Salazar. A lot of this stuff seems to go down in Colorado. So the new amendment to this law defines gender expression to include a person's chosen name or how the person chooses to be addressed. So this includes personal pronouns. This includes titles like Miss or Mr., and you basically are supposed to be compelled to address, a man as Miss, a woman as Mr., if the person chooses. So the athletic company in the first case, XXXY, is pretty explicitly built on the premise that men are men and women are women. It's kind of at the heart of their mission. So that is that, God created two and only two sexes. These are innate in a person from conception. And that is not changeable no matter what the particular administration or local government is doing. So CADA obviously conflicts with this and would require that in this case and in the other case that's kind of a companion now, that the company's employees address customers with what are essentially inaccurate titles. And this violates XXXY's core premise, which is that God created man and woman. Similar problem in the other case, Born Again Used Books. It's a family bookstore. They sell books to anybody. Obviously, they're not turning people away at the door for their identity. But under the act, again, Born Again Books would be compelled to use language that contradicts the owner's faith as well as reality. So both cases, the plaintiffs are being represented by Alliance Defending Freedom. The argument is what you would probably expect. The CADA, this new provision of CADA violates the store's beliefs and the First Amendment by compelling Coloradans to speak against their religious beliefs, their conscience. So there's a good quote here that I think lays the precedent out. The ADF senior counsel, Hal Frampton, said, as the U.S. Supreme Court recently reaffirmed when it ruled against another Colorado law in Childs v. Salazar, the government shouldn't be able to censor speech or force people to speak views they disagree with. End quote. Pretty straightforward. Common sense notwithstanding, the district court refused to grant the preliminary injunction preventing enforcement of this law against both organizations. Cases are now up on appeal in the 10th Circuit. So, as I said, Colorado is kind of ground zero for this. They've been extremely aggressive with pushing the boundaries of non-discrimination law, expanding out definitions, and really pushing this kind of secular agenda on sexual orientation and so-called gender identity for quite some time. So Colorado tends to be fertile ground for these continued cases to try to create good precedent to protect people and organizations from these ever expanding laws. So I just want to point out a couple of quick things. First of all, open to disagreement here, but I think Childs is pretty well applicable here because I think this does end up being a compelled speech and a viewpoint-based compelled speech case, right? In Childs, if you remember, therapists were encouraged by the Colorado law to affirm, various forms of gender and sexuality confusion, but they were prohibited from speaking in a Christian way in particular that helps patients accept the God-given reality of sex and sexuality. So you could approach this topic of gender confusion and sexual orientation, but only from one side and not the other. Viewpoint-based discrimination on speech and essentially compelled speech. Here, I think similarly, the Colorado law demands a certain viewpoint, right? People can be whatever so-called gender they choose, and speech that upholds the immutability of sex is prohibited. So I'm hopeful that the 10th Circuit will apply the Childs precedent. If not, this may very well be another case that goes up to the Supreme Court to continue this question of the tension between religious exercise as well as free speech. I believe this one is being taken up as a straight free speech case, not a religion case, but I don't remember from the record there. But this could be the next chapter in SCOTUS kind of paving the way on this precedent. I also just want to note a basic reality that I find troubling and frankly kind of obnoxious about these cases. In my view, and I've experienced this, such laws are really forcing a problem that doesn't need to exist. There's no real reason to demand that business owners or anyone else use specific titles or pronouns like this. First of all, concerning the pronoun war, you don't use a third person pronoun when you're interacting with a customer. Like there's no point where I'm interacting with someone, I'm going to call him he or she or they or whatever. You don't, it's you. Like you're talking to a person. So just as a matter of grammar, I find this offensive because what they're actually regulating is the way you talk about a person when that person is not present, or at least not the subject of the conversation. Second, it's just easy to simply avoid calling someone Miss or Mr. or anything that is sex specific at all. You can simply talk to a customer as a person in front of you without either offending them by insisting that he must be called Mr. or being forced to speak untruthfully and call him Miss. Right? You can just use neither one. You can. I once worked for a couple of years with someone who identified as transgender in my office, interacted with this person pretty much every day. I never used a false pronoun, never used a false title, and I also managed to never offend this person. The working relationship was just fine. I just talked to the person as a person. It took a little thought, but it wasn't particularly difficult. So personally, I just find this compulsion of pronoun and title use to be like a way to coerce dissenters to bow to the gender ideology rather than solve an actual problem. Like if you're just careful and not rude, like this need not ever come up, frankly. So I think I'll leave it at that. We'll be following this one and see where it goes in the 10th Circuit. And just want to shout out how grateful I am to our friends, John Birch, who is actually a current Good Counselor Project fellow with Napa Legal, and also Chris Chandeville, amazing attorney, and has become a friend of mine and of Napa Legal. So thank you to both of you gentlemen for your excellent work on these cases and a good portion of the cases that we cover on this podcast.
And I would echo what you mentioned, Frank, about really just overcomplicating a problem or creating a problem that didn't already exist, because you can think about even blowing this up to broader levels. So if you're not just thinking about the one interaction between one customer and one employee, you also have to think about, well, the employer has to train the employees on basic customer service tenets for their business, which does that now have to include a session on how we're going to talk to people when they come in, what we do if people say things to us about their pronouns or their sexual identity. Like you're just creating additional steps for a lot of groups, even groups that might agree with you on doing something like this, that really don't seem necessary if, to your point, you just treat people as people when they walk in to your store or to your place of work. And so it seems like it's more of a hassle than it's worth for most people, but it's something that, especially as you mentioned, Colorado keeps coming back to in various contexts, not just therapy context, but now also in things like the business context. And so you're just going to keep seeing it pop up until it's very clear that this is a compelled speech or First Amendment area that can't be reached.
Yeah, this one's the compelled speech cases are really bad. Like in a way, even worse than just generally prescribing one viewpoint. To make somebody speak what is a lie is just so offensive. Yeah, especially when it need not come up. But I don't want to beat a dead horse here, so I suppose we can move on from one problem state to another.
So over to Michigan. Really similar actually to last week's post on Illinois law as well. So just lots of those states coming back up. Here in Michigan, we have two pro-life groups that are seeking an order to block a law that would require them to hire and retain employees that are directly opposed to their mission as pro-life organizations. So we have Michigan Right to Life and Pregnancy Resource Center, which are two different organizations that both have the same general views about pro-life and are employing people that are pro-life. They're helping people in crisis pregnancy situations, health situations, et cetera. And Michigan is trying to force groups like them to hire employees who would just be directly averse to the mission of the organization. The new law, which is Senate Bill 147, requires that pro-life groups carry health insurance for their employees that cover abortion. So this is the way that they're doing it. Both laws obviously in direct conflict with missions of pro-life organizations. And they're doing this by changing how they define sex discrimination in employment law to include termination of a pregnancy. So you're adding abortion and then the coverage of abortion under health insurance into the requirements of the law by changing the term sex discrimination in the employment context. You're seeing a couple of states start to do this. Michigan, I don't think, is the only one. You're also seeing states start to just expand ever more ridiculously what falls into categories of protected classes or groups that can be discriminated against. Been doing some research on this for Napa. You're even seeing states trying to add perimenopausal and menopausal into groups of sex discrimination. So similar to our previous story, you're getting more confusion about well, how would this even come up? How would we address this? Here it's a bit more direct because it's termination of a pregnancy, abortion. It's pretty clear. By making the termination a part of the protected sex category, pro-life organizations would not be able to fire an employee for having an abortion. So the law obviously therefore violates their mission as organizations because they would have to retain employees that are directly averse to what they're doing. And both organizations have actually received applications for employment from pro-abortion, pro-choice individuals. So people who would, in fact, try to work there adverse to the mission and then potentially either receive an abortion themselves or support abortion generally. And they wouldn't be able to fire them just for that lack of fit, essentially. Obviously, a big problem for pro-life groups in general being able to pursue their mission well. And of course, a lot of these organizations depend significantly on their employees in order to continue operating, in order to have the mission in the first place. They can't just say, well, we're going to go down to a staff of 2, 3, 4 people. They can't do that to keep up what they're serving the community with. And these having just one employee like this on staff could be fatal to the organization itself. So you see that it's a real issue boiling up. On Monday, both organizations in Michigan asked the court for a temporary order blocking the state from enforcing this law against them while it goes through the courts. As we mentioned before, Alliance Defending Freedom represents both organizations. And so we're waiting to hear back after that hearing on Monday about what the court will do with this request for a temporary order. But we have to remember that this is broader than just like a health insurance issue or the similar health insurance cases that we've seen in the past 2 decades or so that have moved through the courts. This even is a hiring concern as well. So you're not just thinking about, oh, well, it's only on the health insurance and people can just opt to do something different or they can clear that in advance. Well, now you're reaching to an earlier stage in the process where people will have to consider this even before they would ever offer a potential employee health insurance because they have to think about it in the hiring stage. And it therefore becomes an even greater danger to fit and mission alignment over time because you're making it more difficult for these kinds of organizations to ensure that they can hire for fit and that they can have a mission that will actually be put to practice by the employees that work for them in the organization. And it's also just a way I think that a lot of states have reacted to the Dobbs decision over time. It's just another way of attempting to enshrine in some way abortion into state statutory law. Obviously, this is not directly giving access to abortion or something. It's not exactly the same as what the Dobbs decision does, but it's sort of a reactionary thing to, well, if we're going to let it be our choice in the state, then what's one of the more expansive ways we can add it into our statutory scheme? And we've now moved into the employment context for that.
Yeah, no, it's a great point. How these are, it's a multi-front experiment on different ways that states that are in support of abortion as a right are finding ways to try to enshrine it more and more into the ecosystem of their various regimes. Just two quick comments. For one, to follow up on what you said, the expansion of classes in these non-discrimination laws is frankly just wild to me. We saw in Illinois, it was non-discrimination on the basis of reproductive health decisions. This is non-discrimination on the according to termination of a pregnancy, that somehow that is tied to your sex. Just worth a reminder, these are not innate or highly discriminated against categories of people, right? Like the Civil Rights Act and all that was going on around that in the 50s into the 60s was based on something very particular, right? Someone's ethnicity, skin color, and sex. These are immutable characteristics. You can't change them. You're born with them. To be discriminated against on those bases in most situations is inappropriate, fine. But these are life choices, reproductive health decisions, termination of a pregnancy. This is not some status that you were born with and are being discriminated against because of the way you are. These are choices. So this is very different and very far from the original purpose of discrimination laws as they were enacted in decades past. The other thing I'll say is it really just count me skeptical about the origins of things like this. It was noted in the Alliance Defending Freedom press release on this issue. I think you touched it, but that there were like active and known pro-abortion advocates applying to jobs at Michigan Right to Life and at this reproductive health resource center, pregnancy resource center, rather. This doesn't really happen organically, as far as I know. Like I said this last week when we were talking about non-discrimination in Illinois, like I would never apply for a job at the, Alliance for the Separation of Church and State or the ACLU because it's just obvious that we're not mission aligned. So again, I'm just skeptical that these are organic applications of people who really want to work there and feel discriminated against rather than again, I'm only speculating, but these seem like test cases that somebody found these organizations and these laws and applied to bring about litigation like this. I just don't see this happening in the wild. It just doesn't seem very likely to me. All right. And with that, let's go to our another frequent flyer state, Washington State. So this is very new. We're recording this on June 12th, so you'll get it a few days later. But this was just announced the other day, this lawsuit. It's quite disturbing. I'm going to intentionally leave some of the factual details vague. You can look it up for yourself. But this is involving a high school girl who was on the girls' wrestling team at a Washington State high school, allegedly being sexually assaulted during a wrestling match with a boy who identifies as a girl. There's a lot here that's troubling. I'll just hit a few key points. So Washington pretty openly promotes so-called transgender inclusive sports in high schools throughout the state. Washington also, I think more disturbingly, will not inform the female athletes whether they're about to enter a match with a biological male. And this is going to play differently in different sports, right? Like in track, you're more likely to lose. I know, Alexa, you were a tennis player. In tennis, if you all of a sudden find you're playing against a teenage boy and not another girl, you're now much more likely to lose because they're tend to be stronger and faster and they're more testosterone filled than the girls. But wrestling is different. This is a very close contact sport. It's dangerous. It's intrusive. This is even higher level of inappropriate when you're talking about wrestling. So in this case, the girl who she was 15 at the time, her name is Callie Keeler. She was wrestling for her high school. She wrestled against an opponent who, again, allegedly sexually assaulted her during her match. I'll get to that in a second. She did not know that it was a boy that she was wrestling against until after the match when somebody told her that this opponent it was in fact a male. She noted in I think it was an interview, it might have been in evidence, but she's been wrestling since she was 4 years old. She knows what wrestling feels like. This wasn't just like a normal pin maneuver. So this was the first time she had ever encountered this type of physical violation on the mat in her 11 years of wrestling. She immediately knew something was wrong. I watched the video. You can see the angle's hard, but you can see what's going on. It looks inappropriate, but you can see on the poor girl's face. She looks very distressed. She basically lets herself be pinned. She said this on an interview because she wanted the match to be over. It was really horrible. Then she goes to her mother who had filmed the match. She told her what happened. They went to school administrators. They showed the video. They submitted evidence. And this is where it gets dicey on a different legal level, aside from the transgender sports stuff, although they're related, I think, only speculating. But it's interesting and quite serious. Under Washington law, there are mandated reporter laws, like there are in most places, right? If you're a school and you find out about an alleged assault, it must be reported to law enforcement within 48 hours. It took school officials almost 2 months to report this assault to law enforcement. Maybe a little more on that in a minute. So the girl Keeler and her mother, they filed a lawsuit. Alliance Defending Freedom was also representing them. It's a very ADF heavy day here at the podcast. So the lawsuit was filed against the Washington Interscholastic Activities Associations. That's the sport regulatory body for the schools. The lawsuit's also aimed at the school district and the school's Title IX coordinator for not reporting. So the case is called KMK versus Washington Interscholastic Activities Association. It's been filed in the U.S. District Court for the Western District of Washington. There's also a federal case. The federal government's opened an investigation into the school district for allegedly violating mandatory reporting laws under Title IX. So I've covered a lot of it. There's a lot wrong here. I just want to hit a few things. First of all, again, can only speculate, but this looks like an attempt to cover up something that a state with transgender ideological commitments does not want to be public, right? If school officials are mandated reporters, generally we take mandated reporting law, especially about alleged sexual assaults, quite seriously. And everybody who's ever done a mandated reporter training, you are always told err on the side of reporting, err on the side of reporting, err on the side of reporting. And yet the allegations that they were supposed to report within 48 hours took almost 2 months to report. So again, can only speculate as to why. But we have seen other instances where there were cases of violence and sexual assault committed by boys who identify as girls that are covered up by government bodies. So that's a problem. And I hope that as the evidence comes out and we dig deeper into this, there will be some accountability. As to the incident itself, I mean, I have a little bit of a background. I grappled for several years. So I know, again, I'm not going to say details, but it's very troubling what was done here. What the boy did to the girl in this wrestling match, it's not completely unheard of as a tactic, but it's very widely. First of all, it's illegal under all rules of wrestling, hugely inappropriate, culturally frowned upon in the sport, and it's just gross and dirty. Not going to detail it any further, but the fact that this was, members of the opposite sex in wrestling just makes the whole interaction so much worse, and it's a good explanation of why these kind of mixed sex things should not take place, especially in wrestling, where you're going beyond unfair competition to very close contact, right? Wrestling is obviously a very hands-on sport. Close contact, even unintentional close contact, that is maybe quite uncomfortable. It happens all the time in wrestling. This looked more than an incidental, unintentional touch here. But this is a good reason why wrestling in particular and sports in general should be sex segregated, both because of the physical differences between men and women, but also because of this kind of close physical contact that is inevitable between opponents in wrestling. So if a woman feels uncomfortable wrestling with men, that's completely understandable. And so in my mind, this is made so much worse, right? How detestable that not only does Washington encourage boys to identify as girls and compete in women's wrestling, but also that the state will not inform girls that they're paired against biological boys, right? The girl here doesn't even have the option to opt out of the match. She didn't even know it was a boy she was wrestling until after the fact. Really disgraceful stuff. And I'll probably cut it here, but I hope both the lawsuit and this federal investigation move forward, both to shed more light on how inappropriate this is and to hopefully create some policy changes. Because again, hiding the sex of the opponent is even worse than the normal stories that we hear about boys, winning championships in girls' sports that we normally hear about. Because normally, at least the girls know that they're competing against boys. They might think it's unfair, but they know what's happening to them. And in this case, that wasn't even the case. So horrible story. We will clearly be covering this. It's a fresh case. It was just filed in the district court last week. So more to come.
Yeah, absolutely detestable. And also not lost on us that there's such a rich irony here that it is in almost all cases, the women that suffer from these interactions and situations, especially with the different transgender laws that states have enacted. And yet these are also typically the states that are championing women's rights, women's voices, women's bodies, their choices. And yet in this context, oh, never mind, we don't care that you feel like it's a problem because this other individual who says they're a woman, we're championing that specific person right now. So it's this bizarre, like double standard of we champion all women. Oh, wait, but in this context, only transgender individuals are being championed. And I'm sorry that you happen to be a woman who's struggling with the fact that you are put in this situation where we're not telling you that this is somebody who identifies as a woman but is actually a man. And that irony is not lost on me.
Yeah, no, it's horrible. And it's really watching this ideology clash with itself, right? Like it seemed like it wasn't that long ago that, protecting spaces for women and equal opportunities for women in things like sports, and also doing everything we can to prevent sexual assault against girls and women was like pretty high priority. But that seems to have taken a back seat to this obsession with the trans movement that, like you said, ironically, is advantaging boys over girls and putting girls in danger in the process. So both horrible and ironic. Well, on that less than happy note, we thank you for joining us and hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious freedom and the work of faith-based nonprofit organizations. We'll talk to you all next week. Thank you for joining us, and God bless you all.